Today, I want to talk about how it's possible for somebody to unintentionally make a contract. And that happens because everybody uses electronic means of communicating, texts, emails, emojis. The world has changed, but I don't think every actor has realized that every communication, even maybe you mean it casually, can be taken to court and can be used to create a contract. Because it doesn't take that much to make a legally binding contract if it's signed. In other words, you need the price, parties, closing date, and the address of the property. Those are the bare minimum that you need to make a legally binding contract. This risk is much greater for sellers and landlords than it is for tenants and buyers, because typically a purchase and sale transaction has a due diligence period whereby the buyer can cancel the transaction and get its money back. The seller typically doesn't have a negotiated right to cancel the transaction and get back out of the deal. So when a seller sends communication to a buyer and it sets forth the terms and conditions of the purchase and sale, it can be enough to create a binding contract, or it may be enough to create trouble for the seller to have to go to court to show that it was not a binding contract. In California, a way to enforce the contract for purchase and sale is to file an action for specific performance, and in connection with that, the buyer can record what's called the pendens, which is a notice that gets filed with the court and gets recorded in the county recorder's office that tells the world there's a lawsuit pending that affects this property. And that effectively makes the property unmarketable and gives the buyer a lot of leverage. It's a real word of caution to sellers and landlords to make sure that you are careful in what you put in email, text messages, etc., which can inadvertently create a binding contract if you're not careful. So what you want to say is, this email doesn't create a binding contract even if you accept it. To sign a separate agreement for there to be a legally binding agreement. As many disclaimers as possible to make sure that you avoid giving the other side a shot at having an argument that there was a legally binding contract.